Hello everybody. In this video, we're going to talk about a very important topic: how to resolve issues with cases that are currently pending with embassies and consulates worldwide. How to contact them, what to say. I'll go through that process in detail. So we're going to talk about cases that are stuck in administrative processing, what it is, and what is the timeline for a case that goes through administrative processing at this time. So, very important topics. What are you waiting for? I'll see you on the other side. Hello everybody, and welcome back to our immigration channel. This is a place where you get the most up-to-date immigration news, immigration updates, and everything else that you need to make your immigration journey less stressful. My name is Jacob Sapochnik, and I'm an immigration attorney located in San Diego, California, and we help clients all over the world in all 50 states and dealing with almost every single embassy all across the world. In this video, I'm going to give you some tips how to deal with these embassies, how to contact them when you have a problem with your case, and also we'll talk about administrative processing, what it is, and how to get out of that, and also the timetable that you're going to go through if your case is selected for administrative processing. So make sure you watch this video until the end. I've got really good stuff for you guys. Before we dive into the video, remember, if you're stuck, if your case is stuck, if you need help, if you're frustrated, you need to set up a consultation, don't hesitate. Text me at 619-483-4549 so we can set up a time one-on-one to discuss your case so I can see if I can help you as well. So let's talk about first how to deal with these embassies and consulates if you have a problem before we resort to any of these expedited and before we try to sue the government. How do you contact them initially to understand what is happening with your case? Remember, if you have a case sitting at an embassy right now or is about to be shipped to an embassy from an NVC, most people don't understand or realize that the first thing you should do is actually contact the post directly. Most people don't understand that embassies and consulates do have dedicated staff that are in charge to respond to those emails and to explain to the public what's going on either with their case or answer some general questions. So here's some of the issues that will be appropriate to contact the post directly via their email address that is available on every embassy's website. Number one, a request to review factual determinations, including a request to review a refusal under Section 214B. As you may know, Section 214B is one of the most common reasons why tourist visas get denied, why people that apply for non-immigrant visas, also E2 visas for example, get refused because of lack of ties to the home country. Sometimes these determinations are not right, are not justified, and you can, after a refusal, in a polite way, email the post directly and request a clarification as to why your case was refused. Many embassies and consulates will reply to you at some point with a general idea as to why your case was refused under Section 214B. Again, if your case is refused under that section, you need to email that post directly right after the interview to see if you can get some clarification, and if you do, make sure you print it and save it for future reference. Number two, request for case status update. Imagine your case is pending review at the US Embassy, whether it's an E2 visa or a student visa, and you haven't heard from them for a while. You can email them directly and request a case status. In many cases right now where embassies are open and processing immigrant visa appointments, and those cases are still under review for whatever reason, you can and you should email the embassy directly to request a case status update. Number three, if you have an attorney, your attorney can email the embassy legal questions to clarify whether it's an E-visa or a VAWA case pending or a U-visa or any other consular case that is sitting there. Legal questions, specific legal questions, could be answered by the consular officers to legal representatives. If you have an attorney or somebody who's helping you, you can do that as well. Number four, matters involving scheduling your appointment. So if you want to cancel, if you want to request an earlier date, sometimes it's possible to email the post directly and see if they're willing to accommodate your request. Sometimes your cases could be selected for security advisory opinion, and those can take a long time. You can also email the embassy and find out the status of that inquiry as well, directly to the post via email. Sometimes your cases could be selected for security advisory opinion, and those can take a long time. you can also email the embassy and find out the status of that inquiry as well, directly to the post via email. Number 6, you email them to request explanation in case of a revocation, cancellation, or refusal. Imagine you go to the US Embassy to apply for an e-visa, and at that interview they cancel your tourist visa and they don't tell you why. We had a recent case like that where a client was applying for an e-visa. They had some issues with the case. While they're investigating the investor visa, they've canceled the applicant's tourist visa. We emailed the embassy and they gave us an explanation as to why they've done that. So, very effective way to contact the embassy directly. So how do you contact the post? Most of these posts have dedicated email address for immigrant visas and non-immigrant visas. Make sure you use the correct email address when making your inquiry. When sending an email address, very important tips. Make sure you have a clear subject line as to why you're emailing them. The strong subject line with the purpose of your email and whether the matter is urgent or non-urgent. That should be in the subject line. Next, you need to have the applicant's full name in the body of the email, the applicant's case number, whether it's MVC case number, USCIS case number, anything important for the reference so they'll be able to know who you are and what your case is about. Very important to include the applicant's date of birth. This is one way they track you also in their system as well. And finally, a brief description as to why you're emailing them and a small summary of your request from the embassy at that time. So you send your email, what happens next? Once you send an email, expect a response typically within 30 days. If there's no response in 30 days, you send a follow-up email to the same address. If the post does not respond within 15 days after the second inquiry, send another follow-up. Eventually, the post will respond to you. If you have an attorney who is helping you with your case, your attorney can also make inquiry with LegalNet, which is the State Department's advisory opinion about your case, to see if they can give you more clarification if your case is stuck. But that's only available for attorneys. Now remember, if your case is selected for administrative processing, emailing the embassy is not going to help you that much because your case is under review. So while you can email the embassy and they're going to let you know that your case is under review, we need to understand what is administrative processing and why your case could be selected for such process. What it is that during an interview, a consular officer may determine that further inquiry and further investigation is needed to check on their case before giving an approval. It could be something that you said, it could be something in the documents that they've seen, it could be your actions before coming to the US Embassy from the United States, maybe a past overstay. Whatever that is, they will determine that at the time of the interview and will select your case for further administrative processing. Another reason why a case can go to administrative processing is what is called a database hit. As you know, all visa applicants have their biometrics taken and verified versus different databases that the State Department and Immigration have available for them. If these checks indicate a possible match, or also known as a hit, to a person whom the government holds adverse watch list information, consular officers must clear this hit by seeking further information that the person on the hit list is not that same person applying for the visa at the moment. And that's why when we have a database hit, they'll pull you and take this case to administrative processing. Another reason is what is called technology alert list. Administrative processing can be the outcome of certain visa applications where the applicant's intending commercial or academic activity can trigger some concerns about the possible illegal transfer of technology or information. And this is defined in the technology alert list, also known as TAL. So when the consular officer encounters an applicant that is going to engage in any of the activities that are defined in the TAL list, that case must be flagged for administrative processing, of course. So what's the timetable for cases that go into administrative processing? Everybody's asking that. Well, that will depend on each individual case. In the past, cases that were going to administrative processing, the State Department stated that they should be resolved within 60 days, but this is no longer the case. They're taking much, much longer. Another question we get often is, can applicant be subject to administrative review process every time they apply for a visa? And the answer is yes. Even if you've been subject to processing before, it doesn't mean that when you apply for a new visa, it's not going to happen to you again. And this is specifically true with security clearance cases. Recently, the State Department announced that if your case is subject to administrative processing, you should wait at least 180 days before submitting an inquiry because those cases are taking that long to be resolved. So is it all bad, administrative processing? Well, the only good news is that Cases are not going to be sent to administrative processing unless they're otherwise approvable. Meaning, for example, if you apply for an H-1B visa in the consular process and the US Embassy believes that you should be getting the visa eventually, except from the fact that they need to check a few things about your clearance, your background, a few little things, then they'll send your case for administrative processing. But the point is that if your case is not approvable, meaning that if they're going to deny you anyway, they're not going to send you to administrative processing. So that's a good thing to know. In most cases, administrative processing tells us that you have satisfied, the applicant has satisfied most of the requirements of the visa, and they just need to check a few little things before they give you the final approval. So that's a good sign. In case if your case is dragged into administrative processing, remember you have to wait at least 180 days before you contact the embassy under the same guidelines that I mentioned in the beginning of this video. Hopefully this information was helpful. If you have any questions, make sure you post them in the comments below. If you're here for the first time, don't forget to subscribe to our channel, click the notification bell to be notified for any new videos that we release. And as always, if you need my help, send me a text, 619-483-4549. I look forward to being of service to you as well. Thanks for watching, and I'll see you in the next video.